Yes, Mr. Chairman.
I'm grateful, my Lord. My Lords, my Lady, in our submission, this appeal falls to be dismissed, and it falls to be dismissed because it is based on a number of fundamentally flawed propositions or false premises. Can I identify in introduction the four principal difficulties with the appeal in our respectful submission? The first is that this appeal depends on a proposition which has received little attention in my learned friend's oral submissions, but which lies at the heart of the grounds of appeal, indeed is the first ground of appeal. And that proposition is that the Cayman courts are bound to follow and must follow slavishly and without qualification or amendment the English common law, even where the position in England has been amended by statute, been the subject of criticism, or found no longer to align with the modern commercial world. That proposition is, we say, simply wrong. No authority has been cited for it. It is clear in our submission that Cayman has its own common law and that its courts are free to develop that common law as they see best. While appellate decisions from England and Wales are highly persuasive and may often be followed by the Cayman courts, the Cayman courts are not bound to follow them. And my Lord, I'll spend just a little time, if I may, in developing that shortly, because it will feed into the way I seek to respond to the way the appeal has been put in my learned friend's oral submissions. The second proposition with which we take issue is that the English law on submission to jurisdiction for anti-suit injunction purposes is set out in Geoprosco. And my Lords, my Lady, we say it is not. The English common law on submission to jurisdiction for the purposes of anti-suit injunctions is not and never has been the Geoprosco test. And I'll come on to take my Lords and my Ladies to the authorities which show that to be the case. The third problem with the appeal, my Lords and my Lady, is this. The appellants say that even if the Cayman courts were not bound to follow and apply Geoprosco, the Court of Appeal was wrong not to have applied it, and indeed it must follow from the gravamen of that submission, indeed to have extended its reach from enforcement cases to anti-suit cases in Cayman. And we say that that again is wrong. It in turn depends on the proposition that in developing the common law in Cayman, the Cayman courts should set their face against statutory provisions which abrogate or amend the law, as it was previously stated by the courts in England and Wales, should ignore criticisms of the common law in England and Wales, should ignore how the common law has developed in other similar common law jurisdictions, and simply apply the common law as it was in England and Wales before the legislature intervened.
That seems to overlap quite a lot with your first problematic.
It does, my Lord, although they are slightly different, because the way the position was put in writing, at least, was that the Court of Appeal was bound, come what may, to follow Geoprosco. So
it doesn't really matter that by the time it gets to us anyway.
Well, it doesn't, my Lord, so, which is why I've said it probably assists if I spend a little time on that, because it will then feed into this third, what we say is the problem with the appeal, which is that even if not bound, the court should have followed Geoprosco in this case.
Right.
And we say that's not the position at all.
All these arguments so far are addressing what I might call version one of the appellant's case, which you could be forgiven for having prepared to meet, which was that the statute in England overruled Geoprosco. On the new interpretation of Geoprosco, it didn't. It just confirmed what Geoprosco actually decided anyway.
Well, I was going to deal with that, I think, under the third head, as to why that's not the case, and what Geoprosco said, and why the legislature felt compelled to intervene. And the fourth problem with the case is, I think, an attempt to deal with the third way in which the appeal is now sought to be put, which again, with respect, I think finds no echo in the grounds of appeal or indeed the written case, which is that even if Geoprosco no longer falls to be applied, and you apply the Williams and Glynn test, then nonetheless the Court of Appeal and the judge fell into error. Now, leaving aside whether that's a submission that's open to the learned friend, we say, again, it's wrong because it requires a challenge to the judge's findings of fact, a challenge which was not made in the Court of Appeal and which is not open to the appellant before the board. Lady, finally, by way of introduction, one gets a sense of just how, I'll say, ambitious the submission is that the board should follow Geoprosco as it is now put by my learned friend, by considering how, I think in fairness to him, it was his predecessor, put the position in seeking leave to appeal before the Court of Appeal. And what was said on behalf of the appellant, the effect of the board accepting that Geoprosco should apply. And one sees that in the application seeking leave before the Court of Appeal in this case. In the main bundle...
Sorry, this is leave to appeal to the Court of Appeal, is that?
Seeking leave to appeal to the board from the Court of Appeal. And one sees that at page 735 of the main bundle, where the submissions were addressing the issue of whether the appeal gave rise to a great general or public importance point. And one sees Geoprosco referred to in paragraph 27, but it's paragraph 28 to which I wish to draw attention, and perhaps I can just allow my lords and my ladies to read paragraph 28 and what's said there, please. And it's the second sentence on which I place particular reliance. What seems to be being said on behalf of the appellant there is that if the Court of Appeal had acceded to the appellant's arguments and had applied Geoprosco, then the law on enforcement and anti-suit injunctions in Cayman seemed to have been substantially different to how it had thought it had been in Cayman, and that if the prospective appeal were to be allowed by the board, it may require legislative intervention. I think what was being said is, if my lords and my lady accepted the appellant's case and applied Geoprosco, then that would effectively constitute a statement of the law in Cayman on anti-suit and enforcements that was contrary to the received wisdom as it had been to date, and more fundamentally would require similar legislative intervention in Cayman as was represented by the 1982 Act in England and Wales. And given the way the appeal is now put, that whether or not the Court of Appeal was bound, this board should conclude that Geoprosco should be followed. That rather gives the lie, or that submission in that document rather gives the lie to the suggestion there are any good public policy reasons for adopting Geoprosco as the common law in Cayman. So, my lords, with that introduction in mind, can I deal briefly with the question that I first identified as to whether the Court of Appeal was bound to follow Geoprosco, which, as my lords identify, will feed into the third of my submissions. The first is that no authority is cited for that proposition. The second is that the Court of Appeal in this case clearly thought rightly that it was not bound to follow English appellate decisions, even if they were likely to be highly persuasive. And my lords and my lady will see that from the Court of Appeal's judgment at paragraph 112, Roman 1, at page 296 of the key documents bundle.
Do the appellants argue otherwise in their case?
Well,
because Mr. Quirk, I understood him to accept, at least implicitly, when he was referring, for instance, to Mrs. Justice Carr's decision, that if there was a good reason, the Cayman Court can depart from English law.
That does...
Question of what constitutes good reason.
Well, my lord, yes, which is why I thought it might be worth spending just a few moments on this. The position is slightly unsatisfactory. If one looks just at the grounds of appeal, at page 3 of the key documents bundle, it is pretty clear at ground 1 that what was being said was that the Court of Appeal had erred in concluding they were not bound to apply Geoprosco. And indeed, that the gravamen of that assertion is reflected in the various paragraphs that follow, albeit somewhat pointing in the opposite direction. If one looks at, for example, paragraph 9, it seems to be accepted that English authority was non-binding. And when one gets to the written case, the position is slightly blurred, because what's said is that Geoprosco is part of the law of the Cayman Islands. So it seems to be being suggested that either the Court of Appeal was still bound by Geoprosco, or that by some other route, Geoprosco represented the law of the Cayman Islands.
I took it to be the other route, that
well, I think that's
never been overruled in England. It should be part of the common law unless and until it's some court from it or decides not,
yes,
not to follow it.
and even putting it that way, it's perhaps worth, as I say, spending perhaps a few moments at looking at how the Cayman jurisprudence has developed as to in what circumstances the courts of the Cayman Islands can depart from or refuse to follow authorities from England and Wales, because that in itself was instructive as to what the Court of Appeal were doing here, as recorded in paragraph 112 of their judgment. And the most recent learning on this is the comprehensive analysis of the position by Justice Doyle in the HQP case, which appears at page 2065 of the main bundle. Forgive me, 2063. Now, the question for Justice Doyle, this is a Cayman case, of course, sitting in the Grand Court, was whether the rule in Hounsworth and City of Glasgow Bank should be followed in Cayman. And so here was a case, different issue, where the court had to consider whether to follow, in this case, a House of Lords authority, which had since been modified by English statute. And in deciding that he was not going to follow the English common law as set out in the House of Lords case, the learned judge embarked upon a comprehensive analysis of both Cayman Islands jurisprudence and indeed other common law jurisprudence as to the circumstances in which English precedent would be followed. Now, in my oral submissions, I will not have time to do full justice to the analysis that's undertaken here. But can I just draw attention to some particular parts of the judgment? And perhaps just picking up at paragraph 20 on page 2076, there's a reference to the decision of the board of Willers and Joyce, and what was said by Lord Neuberger there, recognising that in other jurisdictions from which appeals will lie to this court, common law is the local common law, which will often be, but is by no means always necessarily identical to that of England and Wales. And the judge then moves on at paragraph 24, beneath the heading English precedents in Cayman Islands law, to consider in rather more detail than the Court of Appeal did here, the position in Cayman when it comes to the application of English common law authorities. And the judge concludes by reference to the various authorities he considers here, in accordance with the Court of Appeal's conclusion in this case, that English case law is persuasive, but the courts of the Cayman Islands are not bound to follow it.
Well, one can spend a lot of time on the point like this judge did, but that's really the bottom line, isn't it?
It is the bottom line.
I mean, he has a whole series of cases when you needn't follow it, but it seems to be pretty forlorn to try and establish a fixed list of circumstances.
They're all examples of good reason.
Exactly, they're all examples.
They are. And what the judge does is draws the examples from various other common law jurisdictions. So the Isle of Man, Jersey, where, for example, there's another perhaps good example where the Jersey court refused to follow Civil Jurisdiction and Judgments Act English authority, and instead developed their own common law by reference to the Post Act position. Guernsey, Bermuda, Hong Kong, and New Zealand. And drawing from that survey of the various different jurisdictions over the following paragraphs through to paragraph 70 on page 2093, as my lords identify, the judge, that is, summarised the position in paragraph 70, identifying that, first of all, of course, the ratio of a judgment from the Privy Council on an appeal from the Cayman Islands is binding in the Islands. Secondly, that English decisions, even of the House of Lords and now the Supreme Court, are not binding on any judges in Cayman, but they may be persuasive, and in some cases highly persuasive. And then at 3, as my lords identify, the learned judge identifies a number of examples of where there has been good reason shown not to follow and apply the English common law in the various common law jurisdictions to which he has referred. And one will see that shortly that there are echoes of precedent in the examples that are given, particularly at F, I, J, L, and perhaps even N. And having drawn attention to those particular examples, can I just, before leaving this case, draw attention to paragraphs 72 and 73, which we also read.
I think you would say that the substance of this is reflected in paragraph 112 in the Court of Appeals.
It is, albeit far more shortly.
Yeah.
So, dealing with the first ground of appeal, which is really, as I've said, the gravamen of the grounds of the appeal read as a whole, that the Court of Appeal erred in not considering itself simply bound by Geoprosco, that ground of appeal simply falls away. It's wrong. And my learned friend has not identified any authority to suggest otherwise.
Going back to the question Lord Leggett asked, whether it was this point was being contested, I didn't understand Mr. Quirk actually to challenge this aspect of paragraph 112 in the Court of Appeal's judgment.
Not now, no. Although the grounds of appeal clearly do.
I follow your point on the grounds of appeal.
So, and as my Lord Sales has already identified, of course, this does then feed into the third of my submissions as to whether, even if not bound, should the Court of Appeal and now this Court decide to follow Geoprosco in any event. So that addresses the first ground of appeal, and what was the main ground of appeal on the written grounds of appeal. The second point, just before returning to whether Geoprosco should be followed, is to actually look at whether Geoprosco actually represents the English common law on submission to the jurisdiction in the anti-suit context. And our submission there is that the answer to that question is no. Geoprosco has never represented the English common law on the test for submission to jurisdiction for the purposes of an anti-suit injunction. And to develop this submission, I need first of all to return to Geoprosco itself. And could we begin...
Why should it be a different test?
Well, my Lord, as the test has developed, as we see, the test is now the same in the post-1982 Act world, where the test is not the Geoprosco test, and it's recognised that now that the wrong turn in Geoprosco has been corrected, the same test should apply. But before we got to that, one has to ask whether Geoprosco was the test. And it's clear with respect from what the Court of Appeal of England and Wales said in Geoprosco that they were confining themselves very much to enforcement cases.
But I think what Lord Hamblin is asking is whether it makes any sense to have a different test, or whether one shouldn't approach it on the basis that whatever the test is, it ought to be the same in both situations. Well,
the answer is it should be a different test if your test for enforcement is Geoprosco. And the reason for that is because, unlike in enforcement cases, as we'll come on to see, submission to the jurisdiction is not determinative in an anti-suit case. So you can have in an anti-suit case a good and proper, if I can put it that way, submission to the jurisdiction. But nonetheless, the court in the exercise of its discretion will nevertheless grant anti-suit relief. So
you're saying it's not a bar to an anti-suit injunction that there's been a submission to the jurisdiction?
That's correct, and we'll see.
It's all a matter of discretion.
It's a matter of discretion. It's right to say, and I should make this qualification immediately, that if there has been a proper submission to the jurisdiction, then that will weigh very heavily in the balance when the court is coming to exercise its discretion, and in very many cases will prevent anti-suit relief being granted, but it's not determinative of the position. And so that immediately suggests that a somewhat a broader test for submission to the jurisdiction should be adopted. But can we look at Geoprosco and see the limits of the decision first of all? And then we can draw the thread.
Sorry, when you say broader test, do you mean it should be easier to find that there has been a submission to the jurisdiction in an anti-suit injunction case than in an enforcement?
No, it should be a multi, as it is now, a multifaceted test which looks both at the English law as to what would constitute submission to the jurisdiction and the local law, and whether, in substance, as we now know the test is, the steps taken in the foreign jurisdiction effectively amount to a waiver of the challenge to the foreign court's jurisdiction. And that's the modern test. And one can see how that aligns.
Sorry, that's the test, as I understand it, in both enforcement injunctions and anti-suit injunctions.
As it is now.
I thought that you were making a point that before the 1982 Act and the later development of the law, there was some reason, potentially some reason in principle, why the test should have been different in the two cases.
My Lord, yes, and the reason effectively is looking backwards through the telescope as to what the test now is in both, in that it should be the multifactorial test looking at English law, if the case is in English law, and the foreign law as to whether the steps taken in the foreign jurisdiction effectively amount to a waiver of the jurisdictional challenge to the jurisdiction of the foreign court, rather than the Geoprosco type approach where you have these brighter line rules. As soon as you make a challenge on foreign convenience, for example, you're knocked out. You're taken to have submitted to the jurisdiction of the court.
I think the question being asked is, are you submitting there's a principled difference between the two? Should there be a difference?
There should have been if your test in an enforcement case is the Geoprosco one.
I think you're saying, or maybe I'm putting wrong words in your mouth, but that when you're looking at an anti-suit injunction, it shouldn't be an all-or-nothing test anyway. It's more a matter of what have you actually done in the foreign jurisdiction amongst other circumstances which may or may not make it appropriate for the court to decline to grant an injunction. injunction.
My Lord, with respect... precisely.
Whereas if you're coming to enforce a judgment, you basically have to have a rule, or perhaps you don't think so, but that decides whether or not the judgment is enforceable in this country.
And my Lord, with respect, if I may say so, yes. And
Just, well, I wonder if that helps a lot, because usually one looks to see if there is submission to the jurisdiction of the foreign jurisdiction. And I had understood, in fact, from your written case, that you say, well, even if there is, in an anti-suit injunction case, one is looking at a matter of discretion whether to grant the injunction anyway.
yes.
But that still suggests that when you're looking at the submission point as a factor, one is potentially looking at reasonably hard and fast rules before you get to the general discretion that is applied in an anti-suit injunction case at the end of the day.
Well, my Lord, yes, and we'll see how the law has developed, which will probably make this submission easy to understand. But
Right. But then I do repeat my question. What grounds do you say, even in principle, could exist for a different approach to the question of submission to the jurisdiction in the two cases?
well, as the law currently is, none.
No, I appreciate you say that,
Yeah.
but that's what's being urged against you, is that there isn't actually properly, in principle, a difference between the two.
No, but what's been urged against me, somewhat curiously, is that because under the current English law, post-1982 Act, it has been found that the two tests are the same, then if one then goes back in time before the 1982 Act, and you have Geoprosco governing the position on enforcement, then the test should still be the same.
Yeah, but I think the underlying submission, I think it was part 2 of Mr. Quirk's submissions, was there is no difference in principle between the two. Therefore, one would expect the test to be equiparated between the two.
Well, that's where...
Whichever is the main test. You know, of course, he's saying it because he says Geoprosco is the main test. Therefore, it applies across to anti-suit injunctions pre-1982 as well. You accept that post-1982 it is the same test.
Yes.
But you seem, as part of your submissions, to be saying, well, if we were in a pre-1982 world and Geoprosco did represent the law in relation to enforcement injunctions, nonetheless, there would be a different test for submission to the jurisdiction in relation to anti-suit injunctions.
And my Lord, there was, because we have the Williams and Glynn test,
Right.
albeit developed in a slightly different jurisdictional context.
But just before we get into the detail of what the cases say, can you offer us any ground in principle why there should be a difference between the test in the two contexts?
My Lord, yes, albeit I can anticipate the answer to this that my Lord might give, which is that in the anti-suit context, what you're looking for in the exercise of discretion is effectively whether the party has given up, waived their challenge to the jurisdiction of the foreign court. Now, you can approach that in one of two ways. You can apply a hard and fast Geoprosco type rule and say, well, you've submitted to the jurisdiction of the foreign court, notwithstanding you've submitted to the jurisdiction of the foreign court by only taking, for example, a forum non-convenience point, and then deal with this as a matter of discretion and say, well, notwithstanding that submission to the jurisdiction, it's not a sufficient submission to the jurisdiction.
Or it's a submission, but it's not sufficient to outweigh other discretionary factors which point in favour of granting the injunction.
My Lord, yes. Or you could approach it rather differently and say, well, if a party is clearly making it plain that they are challenging the jurisdiction of the foreign court, there's been no submission at all.
All right, thank you.
And that seems to be the rationale for the way that the law is developed. It's not, like so much of what flows from Geoprosco, terribly satisfactory. I accept that. So if one starts with Geoprosco and perhaps page 2004, one sees the issue identified with which the Court of Appeal was concerned by Lord Justice Roskell at letter C to D, which is the enforcement issue. And we know that in Geoprosco, the defendant did a number of things in Alberta. It sought a stay of the Canadian proceedings for arbitration. It did so relying on the Scott and Avery clause that existed, or it said existed in that case. It also applied to set aside service and challenged the jurisdiction of the Canadian courts on the basis of forum convenience. And that was the third ground, which we saw in the course of argument this morning. It's identified at page 2005, letter C, and the conclusion that a challenge on forum convenience grounds was a submission to the jurisdiction, as we saw this morning, is at page 2023 D. Now, in discussing the case of Harris and Taylor, which the Court of Appeal considered itself to be bound, again, Lord Justice Roscoe was keen to, in our submission, emphasise the limits of what was being decided. So if I can invite my lords and my lady to go on to page 2019, please. At letter C, where the learned Lord Justice says it can fairly be said that Harris and Taylor is not a decision, the underlying principle of which should be extended, that we unhesitatingly accept. And then they go on to find that they're bound by it. And then further down this page, when the three principles or propositions to be taken from the decided cases are identified, again, the Court of Appeal is very careful in our submission to make clear that each of these principles applied in respect of the context of enforcement of a judgment of a foreign court. And then, as we saw this morning, the Court of Appeal went on to note, curiously enough, as Lord Justice Roscoe says, that it had never been finally and authoritatively decided whether a defendant who appears in a foreign court solely to protest against the jurisdiction of that court submits to the jurisdiction of that foreign court, and makes the point at 2021 at letters E to F that the court was saying no more than that we are not deciding that an appearance solely to protest against the jurisdiction is without more a voluntary submission. And that then in itself leads to the point I think my Lord Legate identified this morning about the Court of Appeal identifying that they appreciated, this is at letter H on 2021, that on this view the dividing line between what is and what is not a voluntary submission and what is not an appearance solely to protest against the jurisdiction is narrow and may often be difficult to draw satisfactorily. Now, what one takes from that in our submission is that this is a case only about enforcement. It's a decision that the Court of Appeal seems to have reached with some reluctance. They are making it clear in reaching that decision that the principles they identify should not be extended beyond an enforcement case. And they appreciate that the distinctions that they are seeking to draw are not necessarily satisfactory. What appears to have been taken from Geoprosco, and which ultimately led to the intervention of the legislature, is that certainly a forum convenience application in the foreign court would constitute on Geoprosco a submission to the jurisdiction of the foreign court. And while the position was not necessarily clear, because of course the defendant in Geoprosco itself did do rather more than simply apply for a stay relying on an arbitration clause, it was nonetheless thought, as one can see from the Trackerman case, which was an enforcement case again, not an anti-suit case, that Mr. Justice Staunton thought that Geoprosco had the effect that applying in the foreign court for a stay for arbitration would constitute a voluntary submission. And indeed, we also see that Mrs. Justice Carr thought that was the effect of Geoprosco in the strategic case as well.
Well, you might think that was a fortiori to forum non-convenience. Forum non-convenience, you're seeking to set aside service, aren't you?
Yes.
Whereas for stay in favour of arbitration, I don't think you apply to set aside service, do you? Simply,
You apply for an order, staying.
you simply apply for a stay, so you're not challenging. Forum non-convenience could be said to be equivocal as to whether if jurisdiction is established by the service of writ to get that set aside, maybe you're contesting jurisdiction. On the other hand, you could say, well, it's accepting jurisdiction because you're arguing which of two places with jurisdiction should.
My lord, yes.
Yeah.
And we set this out in the written case by reference to some of the other common law jurisdictions, but there were then these fine distinctions being drawn under foreign statutes as to whether applying for a stay engaged with and asked the foreign court to exercise some form of jurisdiction, or whether under the local foreign law it actually meant that the court had no jurisdiction to exercise. And
that might depend from one jurisdiction to another.
And it did.
Yeah.
And it did. And it's no doubt for all of these reasons that Geoprosco was not without its critics, as Mrs. Justice Carr notes, and as we've set out. And ultimately, of course, is why, to put the position beyond doubt, the 1982 Act was enacted. So that's the sort of the contours of Geoprosco, if I can put it that way. And ultimately leading to its abrogation by statute. Alongside that, one has another line of authorities developing. The first of which, to which I need to draw attention, is Williams and Glynn again.
Just before we leave Geoprosco,
Lord, yes.
The court considers that they're actually bound by Harris and Taylor. What was the nature of the issue in Harris and Taylor?
Well, Harris and Taylor is at tab 25, so page 1986.
Well, in a way, it's what the Court of Appeal think it meant in Geoprosco. It's most important.
It is, and I can take me back to
and they seem to have thought it was analogous to forum non-convenience type argument.
Well,
that's my reading of their discussion of Harris and Taylor.
That's absolutely right. That the Court of Appeal understood Harris and Taylor, rightly with respect, to be a case where the defendant in that case was seeking to invoke the jurisdiction of the Manx Court to set aside service against him. But this is...
And they said that was indistinguishable from their case.
They did. And Geoprosco, being an authority from 1976, which has since been abrogated by statute, is one thing. One bears in mind that in itself was based on Harris and Taylor, a decision from 1915 concerned with allegations of criminal conversation with the plaintiff's wife, and then asks, is that a sound base for the modern law of the Cayman Islands on anti-suit injunctions? And one doesn't need to pause for very long to think that there might be something wrong with relying on that type of jurisprudence. But we'll come on to see how the more modern jurisprudence has developed. So I was going to turn to Williams and Glynn at 2551. This was not an enforcement case, nor was it, in fact, an anti-suit case. It was something slightly different. And one sees that from F in the head note, you've got proceedings in Greece and proceedings in England. And the defendants issued a summons in the bank's English action seeking an order to set aside the proceedings on the ground that the English court had no jurisdiction, and also for a stay of proceedings pending the determination of proceedings in Greece. And the judge at first instance held that the application for a stay involved the assumption that the court had jurisdiction to entertain the action, and therefore the question of jurisdiction must be decided first. The Court of Appeal allowed an appeal by the defendant and ordered that the application for a stay be heard and determined first, and then the appeal was dismissed. So this is an application for a stay of English proceedings rather than an anti-suit, but one can see analogous to the anti-suit cases. And if we turn on in the case, it's page 2555, one sees how the submission to jurisdiction point was identified at letter H. And going over to the next page, letter A, and if I can just perhaps ask my lord and my ladies, my lords and my lady to read that passage.
It's not clear to me, though, that in Williams and Glynn, the result would have been the same, or that they were deciding it would be the same, if there hadn't been an objection to the jurisdiction of the English courts. If they'd simply been saying, we'd like a stay.
Yes, if they'd simply been saying we'd like a stay.
What would then the position have been?
The position might then have been that they had submitted to the jurisdiction.
It might be.
It might have
and
been.
I think you want to go further than that, don't you? I mean,
Well,
say that just making a stay application would not be a submission.
Well, making a stay application on the basis of jurisdiction would not be a submission, but making an application for a stay without challenging jurisdiction might well be. And one sees
And presumably, whenever you ask for a stay, you have to give some sort of reason
Yes.
for why you're asking for the stay. So
yes,
I suppose you could identify whether it's a stay linked to some objection to the jurisdiction.
Exactly so. And I think I was working on the premise that the premise of my Lord Legate's question was that there was simply an application for a stay shorn of a challenge to jurisdiction, and that might obviously be different. And once,
I mean, if you've agreed to arbitrate, and you come along and bring proceedings somewhere, and the other party seeks a stay in favour of arbitration, it seems to me fairly strong thing to say you've submitted to the jurisdiction by seeking a stay.
which is why
And it's very hard to I don't see why that should turn on whether you at the same time happen also to be making a challenge to there being jurisdiction in the first place.
forgive me, when I said a challenge to the jurisdiction, I was encompassing within that the arbitration type cases, where you were saying to the foreign court, you should not be determining this because of the arbitration agreement. And one sees this feed into the statement of principle that then appears in Williams and Glynn at 2557. Where the language of waiver is introduced. And if I can perhaps just invite my lords and ladies to read on page 2557 from A to the end of E, please, then that's really the ratio in this case.
Just to be clear, what was the ground on which jurisdiction was disputed in Williams and Glynn Bank?
I think it was an arbitration clause in the security, but let me just...
But was it just was the arbitration clause the basis of both the stay and the dispute to the jurisdiction, or only the stay?
I think it was both.
I'm not sure that's right.
I think the jurisdiction question was going to be before the Greek courts, wasn't it? There was,
Yes.
you should wait.
Yes, forgive me. But there was a jurisdiction challenge on the basis that the English court had no jurisdiction, and then secondly, an application for a stay of the proceedings pending the determination of the proceedings in Greece. So the two, I think, were separate. Forgive me. But one has the point back at 2557 as to the test that was being applied, and one sees actually the statement from Lord Justice Denningsy then was in Redulla's settlement receiving approval. And of course, what one takes away from this is a rather different test to Geoprosco. Here is a test looking at the substance, as whether looking at everything that has been done by the defendant in the jurisdiction, whether in effect there's been a waiver, that the defendant has waived his objection to the jurisdiction. Now, this was a decision from the House of Lords in 1984, so after the 1982 Act, and true it is that Geoprosco was not referred to in this case, but nor, for reasons that the Lords and my Lady will appreciate, would we say that that's surprising, given that Geoprosco was an enforcement case and this was not an enforcement case. One then goes forward still further to Rubin, much more recent decision of the Supreme Court at 2252, and the relevant passages, which I think you were shown nearly all of this morning, here at 2298. Where at 159, Lord Collins identifies the general rule in the ordinary case in England is the one to be taken from Williams and Glynn, which we were just looking at, namely that the party alleged to have submitted to the jurisdiction of the English court must have taken some step which is only necessary or only useful if an objection to jurisdiction has been actually waived or if the objection has never been entertained at all. And then at 160, he identifies that the same general rule has been adopted to determine where there has been a submission to the jurisdiction of a foreign court for the purposes of the rule that a foreign judgment will be enforced on the basis that the judgment debtor has submitted to the jurisdiction of the foreign court. And he then sets out a number of post-1982 Act decisions which hold to that effect. And then the very last case in that list was the Eastern Trader, which was an anti-suit case. So once the general rule in England is the rule in Williams and Glynn, the same general rule has then been applied in the post-1982 Act enforcement cases and also in the anti-suit cases. And just with that last case in mind, the anti-suit case, if we go back to the decision of Mr. Justice Phillips, as he then was, at page 1976, so this again is an enforcement case, but just to see how the law had developed post the Act, I think my learned friend took you to paragraphs 29 to 30. If one then goes on to 31 to 33, one sees how the modern English law had developed on enforcement too, as recognised in Rubin after the enactment of the 1982 Act. perhaps I hope to go back to the question that my Lord Sales asked me some time ago. On the English authorities, you have the submission to jurisdiction cases running in two channels. Geoprosco takes a wrong turn. In the meantime, and subsequent to Geoprosco, the rest of the law on submission to jurisdiction per Williams and Glynn develops in the rather more satisfactory way that it did. After the wrong turn in Geoprosco is corrected by legislative intervention, the two channels merge together, as one would expect. So, my lords, Geoprosco was only ever about enforcement. It did not prevent the common law of England, still less the common law of Cayman, developing in a different way in other contexts. And once the wrong turn was corrected in England, the law on submission for enforcement and indeed anti-suit and other purposes has, as one would expect, been held to be the same. But one can't reverse reason from where we have got to in England, in Rubin, to the proposition that pre-Rubin, pre-legislative intervention, the wrong turn in Geoprosco, expressly limited to enforcement cases, should be aggravated and made still worse by dragging the anti-suit and other cases with it.
So the law now, you say, is what, as set out in Rubin?
As set out in Rubin.
Across the board?
Yes. And that's the test that the judge applied and ultimately the Court of Appeal accepted was correct. I'll just show you, my lords and my lady, the point about discretion as well, for completeness. That's SAS Institute at page T344. Paragraph 114.
This is Lord Justice Males.
It's Lord Justice Males. And this is the discretion point.
Right, yes, I mean that seems to be, as you say, more on the general discretion rather than on the criteria for submission.
Yes, and I just really bring that to your attention now by way of completeness, in that you have this additional overlay in the anti-suit cases, but the test for submission is now the same. And what the appellant's appeal now turns on is persuading the board to ignore 50 years of development of the English common law and to go back in time to 1976 and apply the common law as it was then, and worse, apply the common law as it was developed expressly by reference to enforcement proceedings and apply it to anti-suits.
I think you said that the judge in the Court of Appeal did apply the Rubin test. Can you just point us to the parts in their judgments where that's clear?
Yes. The position does not appear as straightforwardly in the judge's judgment, because, as my lords and my lady will recall, Geoprosco wasn't an issue before the judge. Geoprosco was a latecomer to this piece in the Court of Appeal. So he did not have to address Geoprosco or Rubin. So he applied the SAS test, which is at paragraph 106, page 183 of the key documents bundle.
Sorry, which page?
Page 183.
Thank you.
Paragraph 106, where it was not in dispute at first instance before him that that was the test that ought to apply.
So in terms of submission, the test was whether they're taking a step which goes beyond a challenge to jurisdiction.
Yes. And then, of course, as we saw this morning, we had all of the judge's findings in that context by reference to the disputed expert evidence, and he found that there had not been any such step.
I see that again at 195, 215.
My Lord, I'm grateful. And then it actually runs through his analysis from 195 through to 207, where he expresses his ultimate conclusion. But 202 and 204 are also important.
I find that quite hard as a statement of the test. I mean, why aren't you taking a step that goes beyond challenge to the jurisdiction if you're applying for a stay in favour of arbitration?
Well, I think well, that the statement in SAS has to be read against Rubin and Williams and Glynn, because SAS follows. So when we're talking about a step beyond a challenge to jurisdiction, that's in light of the modern law in England as it now is. And that's why one doesn't see the type of reasoning that I've just been attempting to go through in the judge's judgment, because none of this was an issue as to what precisely was meant by a step beyond a challenge to jurisdiction, and the judge reached the findings that he did. And in the Court of Appeal, one has the consideration of Rubin at paragraph 99, starting at page 287. It's paragraphs 99 and 100.
So a step beyond challenge jurisdiction is one which is very necessary or useful. The objection hasn't been waived.
Yeah, effectively to amount to a waiver of the objection to the jurisdiction. And that one can see that that's effectively what the judge, it was the test that the judge applied here. It's saying, well, look, on the basis of the Pakistan expert evidence and my own analysis, the applicant for the anti-seat relief had never given up its objection to the jurisdiction of the Pakistan court.
Oh, its objection was simply that there had been an agreement to sue elsewhere.
It was, yes, it was reliance on the exclusive jurisdiction clause. And the error that had been made in Pakistan was addressed in the evidence, where it was made clear that to the extent that the challenge would have to be taken forward, if it was taken forward, then it would be corrected to the right version of the clause in the shareholders agreement. And then just for completeness, one has paragraphs 112 and 113, where the Court of Appeal rejects the application of Geoprosco and adopts the test from SAS and Briggs. And indeed at 113 cites with approval the passages from Raphael on the antecedent injunction. And in fact, one sees from the passage that's cited with approval from Raphael at paragraph 113 of the Court of Appeal's decision that that's effectively consistent with the test in Rubin. Now, My Lords, my Lady, I think that brings me to the third heading, which is a topic which I've largely covered in answer to the questions asked of me as we've gone along, but is whether, even if not strictly bound to apply Geoprosco, as it was not, the Court of Appeal should have applied it and indeed extended its reach to anti-suit cases, and whether now the board should do so. Here again, one starts perhaps with that which is not in dispute, that English common law authority need not be followed as a matter of Cayman law if there is good reason not to, and I've identified the particular examples which are engaged from the analysis of Justice Doyle in HQP, which we say apply here. You have here a common law rule that has been abrogated by statute, been the subject of much criticism. One can see, even from the discussion before the board on this appeal, that the decision in Geoprosco is with respect unsatisfactory and its meaning and effect unclear, all of which individually would justify not following it in Cayman, but which collectively, in our submission, conclusively point against doing so. One also has the point, as we set out in our written case at paragraphs 63 to 80, that no other common law jurisdiction continues to apply the Geoprosco test. The position has either been changed by statute, as it was in England and Wales, or not applied by the courts of those other jurisdictions. For the purposes of my oral submissions, may I just perhaps summarise the position? In Australia, there has been statutory intervention where the Foreign Judgments Act mirrors Section 33 of the England and Wales 1982 Act. In New Zealand, there has been no legislative intervention, but Geoprosco has either not been followed or considered to be good law, and the approach seems to mirror the modern approach in England as it's been developed in light of the 1982 Act. Similarly, in Canada, Geoprosco has not been followed. In Singapore, there have been elements of both, by which I mean there has been both legislative intervention in the form of the Reciprocal Enforcement of Foreign Judgments Act 1959 as amended in 2019 to reflect the 1982 Act in England and Wales, but equally, even before the intervention of the legislature, Geoprosco was distinguished and not followed. In South Africa, the position seems to be similar to that as I've just described in Singapore. In Hong Kong, there has been legislative intervention via Section 4 of the Foreign Judgments Restriction on Recognition and Enforcement Ordinance. And that leaves then BVI and Bermuda, where there has not been legislative intervention, but the courts have nonetheless refused to follow Geoprosco. And it may just be worth turning up briefly at Justice Bannister's decision in the British Virgin Isles in Star Reefers, which is at 2359. And I should say that what is said by the learned judge in this case is strictly obiter. But nonetheless, he felt, because of the way the application was originally presented, that he should deal with the point. So one sees at paragraph 4 at 2360 that the application before him was originally presented on the grounds that JFC had submitted to the jurisdiction of the English High Court by seeking unsuccessfully to challenge its jurisdiction and to argue forum. That seems to me to raise a point of considerable importance, so that although I'm not persuaded by this submission, it seems to me that because a similar point may arise in future, I should set out my conclusions on that issue. And the judge then does so at paragraphs 6 to 9, where he expressly considers Harris and Taylor and Henry and Geoprosco and declines to follow Henry and Geoprosco. And perhaps I just invite my Lord and my Lady to read paragraphs 6 to 9, which set out his reasons for taking that step. And my lords, my lady, we say the same considerations apply here, just as Justice Bannister said there at the end of paragraph 8, that it would be a retrograde step and contrary to the spirit of the provisions in legislation in that jurisdiction to introduce into the law of the BVI rules which ceased to be part of the law of England 30 years ago. Quite so, and perhaps even worse, to seek to introduce such law into the law of the Cayman Islands 40 years or more after they ceased to be the law of England. And his comment at the beginning of paragraph 9 is perhaps also apposite.
I think that has a strong echo of Lord Justice Denning in the Dulles.
It does, my lord, yes. Now, to complete the survey of the other common law jurisdictions, Bermuda has followed this decision in Star Reefers rather than the old English law. Now, what's said against that in paragraph 15 of the appellant's written case is that there is a good policy reason for the rule in Geoprosco to be adopted. That, with respect, is a difficult submission to understand in circumstances where it was abrogated by legislation in England and not followed or abrogated in every other common law jurisdiction. It also engages again the submission made to the Court of Appeal, to which I drew attention towards the beginning of my submissions this afternoon, where the appellant seemed to accept that if the board was to be persuaded that Geoprosco should represent the common law of the Cayman Isles, the Cayman Isles legislature may then have to intervene, as the English legislature did, to correct the wrong turn that had been taken.
Also, it seems to me it might be said it's actually not strictly a matter of policy, but it's also justice, since the underlying justification that a party should be bound, both in an enforcement case and in an anti-suit case, by something that they have done voluntarily in another jurisdiction amounting to waiver. If what they've done, judged using this language by the light of nature, or using Lord Justice Denning's formulation in Dulles, any reasonable business person would regard themselves as having been objecting to jurisdiction rather than submitting to it. Might be taken to be somewhat surprising that they should be caught out.
My lord, precisely so. Now, for completeness, I should perhaps just spend a moment or two on the two Cayman authorities that have been referred to, at least in the written cases. Banco Mercantil del Norte is a Cayman enforcement case where it does not appear that Geoprosco was cited, but the post-1982 Act English jurisprudence was and was effectively followed. And I just flagged that because that's a case that was then discussed by Mrs. Justice Carr in Strategic. And given the reliance that's been placed on this, I should perhaps just say something about it. The first thing to say about it, of course, is not a Cayman case. And with all due respect to the judge in that case, she was making findings of fact on the basis of expert evidence, rather than deciding what the law of Cayman was as a Cayman judge sitting in Cayman with the benefit of submissions on Cayman law. It was also a case involving, among other things, the question of whether a judgment obtained in Singapore was enforceable in the Cayman Islands. So again, it was a case involving enforcement rather than an anti-suit case, and it's in that context that Geoprosco is discussed. It was also a case where the defendant had done rather more, and where the submission to the jurisdiction of the foreign court was relatively plain. So, for example, if we were to turn to page 2370, one sees at paragraphs 11 and 12 that there was not only a summons to stay the proceedings pending arbitration, but also a stay on the ground of foreign non-convenience. But then in the further on the alternative, what was sought was an extension of time for service of the defence, discharge of the injunction and an inquiry into damages, all of that being supported by a 15-page affidavit which went into the merits of the position. So again, a very different case from the present. And then when it came to discussing Geoprosco at page 2390, the learned judge noted at paragraph 99 that Geoprosco had both been doubted and or disapproved by academic commentators and in a number of Commonwealth courts. And at 101, we see that both experts in that case were clear that the Cayman Grand Court would follow English law unless there is good reason not to do so. So again, an acceptance by the experts in that case that the Cayman Court was not bound to follow Henry and Geoprosco, and the learned judge then deals with some of the criticisms that were caution that was expressed by the Court of Appeal itself in the Geoprosco case. Then at 102, interestingly, that the learned judge thought in this case that Geoprosco meant that the application for a stay of the Singaporean proceedings pending arbitration would have been without more, according to Geoprosco, a submission to the jurisdiction of the Singapore court.
Well, that's what Mr. Justice Staunton thought.
Indeed, and that's why no doubt the legislature felt compelled to intervene. And the judge then goes on to find that while in Cayman the courts would not disregard Geoprosco, her conclusion at 105 is that she finds that Cayman law requires the court to look objectively at all the circumstances in the round to determine whether there has been a submission to the jurisdiction of the foreign court. Such a submission can take place without a full contest on the merits. Now, that
is a bit vague.
Well, it's why I started by identifying the context in which Mrs. Justice Carr, she then was expressing her conclusions. She was not only a hostage to the submissions that were made to her, but to the expert evidence that she received. And it led her to the conclusion that she's reached, which was sufficient to dispose of the matter before her, making findings of fact as to what Cayman law might be for these particular purposes.
Well, this isn't an authority on Cayman law, this case, is it?
No, but to the extent...
When you find foreign law as a fact, that doesn't make your decision an authority in the foreign jurisdiction.
No, indeed not. But just to deal with the submissions that have been made in reliance upon it, of course, this isn't... Whatever it is and it isn't, and with respect, it is vague, it's not Geoprosco. It's something different to Geoprosco in terms of looking at objectively at all the circumstances in the round to determine whether there has been a submission. A straight application of Geoprosco would be far more certain to that. That's the first point to note about it. The second point is that when then the judge expresses her conclusions at 107 as to submission, she finds that there was more than a mere application for a stay, and she identifies what they were. And then, interestingly, at the bottom of 107, Roman 2, she applies the passage from Akai and People's Insurance as to the court considering the matter objectively. So she's actually applying some of the post-82 Act jurisprudence when reaching her own conclusions. So it doesn't have any force as precedent. In any event, it's an enforcement case. To the extent it deals with Geoprosco, it does not apply it without modification. In fact, the test, such as it is that's identified, looks more akin to the modern English law than it does to Geoprosco. And some of the post-1982 common law jurisprudence is applied in any event. And so, my lords, my lady, for all of those reasons, we say there is a raft of compelling reasons why Court of Appeal was right here, in this case, not to apply Geoprosco, which would, to echo the words of Justice Bannister, represent a retrograde step. That leaves, I think, the fourth issue which I have to address, which is a response to my learned friend's third argument this morning, which I think was to the effect that whatever test applies, that the judge erred. Now, leave on one side, that doesn't appear in the grounds of appeal or in the written case, albeit I do note that this is an entirely new argument. It's also, with respect, a thoroughly bad one. The judge was obviously correct, as the Court of Appeal found, to apply the test that he did, as to which there was no dispute between the parties at trial before him. And the only way, with respect, that my learned friend can even begin to get this argument off the ground is by mounting a full attack on the judge's findings of fact based on the expert evidence that he heard. And the position, we've looked at some of the passages in the judgment. The position is neatly summarised, if I may say so, by the Court of Appeal, where, having, as we looked earlier at paragraphs 112, 113, rejected Geoprosco and approved SAS Institute and the passages in Briggs and Raphael, the Court of Appeal concluded at 1.1 floor, applying this learning to the circumstances of the present case, it cannot be said that the judge was wrong in principle to regard SPV 21's Order 39 and Section 4 applications as genuine attempts to, quote, to do what it can to resist the Pakistan court's assumption of jurisdiction, and as not being inconsistent with treating the contractual forum as the primary forum for the resolution of the parties' substantive disputes.
But that's picking up language from Raphael.
It is picking up language from Raphael, but it reflects the judge's conclusions that we were looking at earlier at paragraphs 202, 204 and 207 of his judgment, and also 195.
I think, well, certainly the second quote is from 202, I think, the judge's judgment, isn't it?
My Lord, it is. It's from 202. So the findings are from 194 to 207, and the key findings are at 195, 201, 202, 204, and then the conclusion is at 207.
In terms of what test the judge was applying, I think one essentially sees that from 201 and 202 on page 217. Because you see the submission, the applicant maintained that the Order 39 application was in substance only contesting the jurisdiction. Then in 202, he accepts that submission, so he's applying a test of what in substance did this amount.
Exactly, which is consistent with the looking at all the circumstances, having regard to the foreign law as well as the domestic Cayman law, has the applicant effectively waived their reliance on the exclusive jurisdiction clause?
Yes, and the reasoning that follows is really just expanding upon that basic point.
It doesn't. My Lords, unless there is anything else that, and my Lady, unless there's anything else that I can insist, that was all I was proposing to say by way of oral submission beyond what we've already said in writing.
Yes, thank you very much, Mr. Chairman. Right.
First is in relation to the question forum non-convenience and whether a forum non-convenience application is a submission to the jurisdiction, and was Geoprosco wrongly decided on that point. My Lords, if we look in the bundle at page 2005, main bundle, at letter C, we see that what happened there, this is within Geoprosco, what happened was that the defendant served a notice of motion on the plaintiff. So it's a single document. Within that document, it had, it was an order seeking set aside on 3 grounds, and then a further alternative 4th ground, which was on the basis of the stay. On the 3 grounds, first was irrelevant, second was plaintiff's affidavit seeking leave to serve out of the jurisdiction was defective. In other words, it was a submission by the defendant that the plaintiff's affidavit seeking leave to serve out was defective, and it was said that amounted to submission. And then third was that it was not the forum convenience. So all of those dealt with in the same document. Then at 2023, please. The second paragraph on this page starts with the court's conclusion about the effect of the application for a stay, in other words, ground 4. That's the first sentence. Then the second sentence deals with grounds 2 and 3, namely the plaintiff's affidavit and support point and the forum non-convenience. That is the only sentence that deals with grounds 2 and 3. The next sentence, which starts Harris and Taylor, says then Harris and Taylor and the cases upon which that decision is founded are, in our view, indistinguishable in principle from the present. Compel this court to say that it's a submission, they took their chance, their advisors thought it's their advantage to do so, they have lost, they're now bound. All of that, from the word Harris down, applies to everything. It's not by reference to the forum non-convenience point or the affidavit point. And actually, Harris doesn't even deal with the forum non-convenience, so it wasn't a citation to a particular finding in that case.
Sorry, I can't pretend that I'm fully on top of Harris and Taylor, but Lord Leggett indicated that actually in substance it was a forum convenience.
My Lords, as far as we can, so Harris, which is at 1986, it was plaintiff brought an action against defendant in High Court, the Isle of Man, obtained leave to serve the defendant with the writ of summons. Defendant subsequently appeared conditionally, applied to the court to set out the order for service out of the jurisdiction and the writ. And the defendant was domiciled in England, and then the court dismissed the application.
Well, if you look at page 2011 in how the Court of Appeal in Henry and Geoprosco describe Harris and Taylor,
Yes.
what they boil it down to at the bottom of that page is that it was a case in which the court had a discretion whether or not to exercise jurisdiction over the defendant, and it heard a plea that it could not and should not exercise jurisdiction, but decided that it should.
Yes.
So that would seem to be exactly the situation in a forum non-convenience case.
My Lord, I understand that. Yeah.
And so that was why it seemed to me to tie in when it said that the second and third grounds of appeal, well, that would be on the wrong side of the line.
Yes.
And that it's indistinguishable from Harris and Taylor.
Yes, or at least perhaps on the forum point, but not on the affidavit point.
No, maybe not the affidavit point, but it's pretty strong if you can't even say that the affidavit was defective without having submitted to the jurisdiction.
I mean, all of that is to say that, of course, a forum non-convenience argument is solely protesting the court's jurisdiction. And whilst it might be against the backdrop that there may be more than one court that has jurisdiction, the defendant is saying it shouldn't be there. And that falls, I submit, within the Geoprosco general principle that it's solely protesting the court's jurisdiction. And to that extent, we think, and I submit, that Geoprosco got that wrong, that on the forum non-convenience aspect.
What's the difference in that and saying, well, you shouldn't be here because there's a Scott and Avery clause and you should have arbitrated first before you come here? They shouldn't be here because you haven't gone to arbitration first.
Because it's the difference between the two is that the latter is not purely and solely about protesting jurisdiction.
Well, I mean, that all depends how you draw this very subtle distinction, doesn't it?
Of course, once you're near to the line, of course I accept that. And in most cases, it becomes clearer. But there will inevitably be situations close to the line. And in my submission, that clear line of if you solely protest jurisdiction, then that's not a submission. If you do something more than that, it is.
But do you have a principal basis for applying that line? Mr. Chapman's approach based on the case is one of waiver, effectively. Do you have a principle we can apply?
As to why that line should be applied.
How you decide whether the line's been crossed or not.
Well, so the way that the line has been crossed in the cases that I showed you earlier is if you simply, so take the example of Geoprosco, if there hadn't been that additional submission to say to the court, and there's a condition precedent in the contract, which means you shouldn't be dealing with this at all, from a contractual point of view, that takes you over the line. If on the other
forgive me for interrupting, but I have difficulty with that submission because earlier on when we were asking you about construction of an arbitration clause, and there may be an issue, does the arbitration clause cover this dispute? I understood you to accept that if you have that argument, you're not submitting to the jurisdiction.
correct.
How is that different from a Scott and Avery clause, where it's just a question of construction of the arbitration clause as to what effect that clause has as between the priority between arbitration and the domestic, the court hearing the application?
Yes, well, I think the distinction is that in the arbitration sense, where you're arguing that it's an arbitration clause, even if you get into the context of what that clause applies to or doesn't apply to, it is all about whether that court has jurisdiction or not, as opposed to in the Scott and Avery, and of course we are looking at something that's quite historical, but anyway, in the Scott and Avery situation, you are looking at a situation where even if the court has jurisdiction, it shouldn't it should order the parties to go away and go through the arbitration process as a matter of contract, and that's therefore it takes you beyond simply saying you court don't have jurisdiction. It's not just confined to that. Yes, I appreciate that there are fine distinctions when you get down to it.
Unfortunately, having jurisdiction, or what constitutes having jurisdiction, the more one probes it, the more ambiguous it gets. I mean,
yes, and the same, I mean, you know, what amounts to a waiver of jurisdiction, there will be whichever way one cuts the test, there are always going to be difficult cases as to what amounts to a submission. And my overarching submission is that what one doesn't do is throw out of the window a well-established line of authority which has been applied in a number of cases for over 100 years, and say instead, there was a new line called Williams and Glinsbank, we should just apply that and forget Geoprosco. That's really the overarching point I make.
All right. It may be you're going to come to this later on, but just to make sure that I've got your submission on it. You look at paragraph 161 in the Rubin case, which is page 2299.
Yes, ma'am.
Lord Collins, having said on the question of characterisation whether there's been a submission, says, well, it's a question for English law, but the court doesn't necessarily sort of transpose the English approach to submission, nor does it necessarily accept the foreign approach to submission. And at the end he says the question whether there has been a submission is to be inferred from all the facts. So isn't that looking at sort of the question of substance, whether there's been a submission, and saying, well, the question of characterisation is for the first instance court inferring that from the facts.
Yes. My Lord, I think all of the tests are essentially based on that. Of course, we're dealing here on this page, as you see from the dates of all of the cases, with cases which post-date the 1982 Act.
Yes, certainly.
Are in the 1982 world. So we do have to look at this with a little bit of care. But in terms of the overarching point, my Lord, I don't disagree with that.
But, all right. If you were in the pre-1982 world, would the question whether there'd been a submission be different from that? As a matter of substance to be inferred from all the facts, do you say?
Well, within the parameters, or it would have to be within the parameters that from Geoprosco that I went through with the court earlier in my submissions. But within those parameters, of course, the court is then looking at what has gone on. I mean, that's on the clear, bright line, is it solely protesting jurisdiction? That's not good enough. Do you need to have an argument, submission on the merits? No, you don't. And then, of course, then within there, one is looking for all the situation in the round.
Right. And sorry, my final question just arising from that. If the test is a matter of substance where the question of characterisation is for, in this case, the Cayman court, and it's to be inferred from all the facts, you say that if that's the right approach, that the judge erred in any way in characterising things, having heard the evidence on the facts in the way that he did?
My Lord, I do. Because there is still, it's not just a kind of open with no parameters. The test on the basis of Geoprosco has those parameters I just mentioned.
Right.
And what the judge didn't do, and actually he can't be criticised because it wasn't actually argued in front of him, the case of Geoprosco. But with the right test would say you're not looking for the substantive merits. And that was exactly what Justice Seagal was looking for. And that was not in accordance with the common law.
Yes, thank you.
Can I just ask you, my Lord Hamlin asked about what the underlying principle on your approach would be. But as I understand it, you would have, maybe I'm wrong, you would have no particular problem with conceptualising your approach as a waiver approach. You would just say, what constitutes waiver? We have to look at the authorities, including Geoprosco.
Well, exactly.
Yeah.
And that's really the point that I made earlier on, which is the Williams and Glinsbank test, which Williams and Glinsbank, bear in mind, was a 1984 case. It's right on the cusp of when the law here changed. But it didn't just throw, I'm going to deal with this now, but it didn't just throw Geoprosco out so far as the common law is concerned prior to that time. Can I then just deal with, so that's the first point about forum non-convenient. The second point is about the different test, whether there should be a different test at, in relation to enforcement and recognition and anti-suit injunctions. And each of your lordships asked my learned friend at various times whether it was his case that prior to the 1982 Act, there was a different test for submission in respect of enforcement, recognition, and anti-suit injunctions. And my learned friend said, after some discussion, yes, that was his position. Well, with respect, that makes no sense. The same test, whatever it is, must apply to submission to a foreign jurisdiction. Whether one is considering that question during the foreign proceedings, i.e. in an anti-suit injunction situation, or after the foreign proceedings have ended in enforcement proceedings, it could lead to absurd results if a different test applied simply depending on when you happen to be looking at what happened in the foreign proceedings.
Why?
Well, let's say that steps were taken on Tuesday in the court, those court proceedings, and that was doing X, Y, and Z. And the court looked at those and said, does that amount to a submission whilst the case is ongoing? And it came to one view. And then a week later, the same court is looking at whether the judgment which has emanated from that exercise is enforceable, and whether those same activities on the Tuesday amounted to submission. to then say, I'm now going to apply a different test.
But the way that the law seems to have developed is that for anti-suit injunctions, the court's exercising a discretion, and so it's not applying a bright line test. Has there been a submission or not? There can be degrees of submission, if you like. It can have, it can have done conduct which, on any view, would amount to accepting that the merits are going to be decided, or it might have been the other extreme, or might be somewhere in the middle. And the court can just take into account what degree of submission or waiver, whatever, in its discretion. Whereas when you come to enforce the judgment, I don't know if the law's got to the same position, but it may be in the position that it's an all or nothing question. Either there's a submission or there isn't.
Well, Lord, in my submission, there's a number of potential problems with that position that was put forward by my learned friend. The first is that it would be rather unsatisfactory if in every case of an anti-suit injunction one says, there's no sort of principal basis here, it's all down to the discretion of the judge, sort of ignore all the other bright line rules that might apply. That would be unhelpful, I would suggest, for first instance judge. Second is that even on my learned friend's case, they're not saying there was no principled test. What they say is, and this is in response to questions from the board, that it was the Williams and Glinsbank test. But even on their position, they're not saying this is sort of floats in the ether and it's all down to a matter of discretion. What you're really being what you're being asked to do is to say, so far as the anti-suit position is concerned, is it Williams and Glinsbank test or is it Geoprosco test? And now, so far as that is concerned, as my learned friend accepted, Williams and Glinsbank was not an anti-suit injunction case. It was an application for a stay of English proceedings. Nothing to do with foreign proceedings at all. It doesn't establish a rule for anti-suit injunctions at all. And so when my learned friend says, well, it just has to be Williams and Glinsbank, there's no basis for that. Williams and Glinsbank came up with this second track. My submission is those can be given effect.
Sorry, just on that, didn't this court in Rubin essentially take the Williams and Glyn test and say it applies across the board as a general rule?
My Lord,
we've been referred several times to paragraph 160 on page 2298, and the reference to the Eastern Trader, which was a PSI case.
My Lord, it does, exactly. And what it's doing there, one has to remember, that's in the post-1982 world.
You accept that's the law now, here?
Yes. But the point is that, of course, that's not what we're really concerned with. We're concerned with the common law prior to that act. And if one looks at that page, it's 2298 of the main bundle. Para 160, you'll see there that all of the cases which are cited there are all post-1982 cases. They're Adams and Cape Industries, etc. So they're all the sort of the classic cases on the 1982 Act. Similarly, that final case, the Eastern Trader, 1996, and my lords, you might recall that we went to that in the main bundle at 2135, and that was a case where the court was applying the 1982 Act, not the common law. That was the anti-suit case. Now, of course, Cayman does not have the 1982 Act. It has the common law. And so the position remains that we must discern what the common law is. And the long-standing position is Geoprosco, which can be reconciled with Williams and Glinsbank on the basis I submitted earlier.
Yes, thank you.
Lord, that's dealt with points 2 and 3. I'm now on point 4, which is whether there is a good reason to disapply English common law in the Cayman Islands. And my lords, could I ask you please to turn up page 2293, which is within Rubin itself. This is Lord Collins. And could I please ask you to read paragraph paragraph 129.
Right. That's talking about development of the law. Here we're talking about a separate system of law. So Cayman law isn't saying, should we develop the law? Saying, what is the rule of Cayman law?
My lord, yes, absolutely. In all other respects, though, save for if there is a good reason, then Cayman law is English law. And so one is asking, is there a good reason to change it? And in terms of where we are on this principle around the world, my submission is the principle that's set out there by Lord Collins applies here, namely that, and that's because the general, albeit not exclusive practice in this area is that it has been a matter for the legislature. And in circumstances where the common law can be given sensible effect, as it can here, then there's no justification for simply abandoning a line of common law which has stood for over 100 years.
Yes, thank you.
Although the final point is on findings of fact in the judgment. The expert, I just want to be clear, the expert evidence before Mr. Justice Segal was from Pakistan law experts. That was about whether what had happened in Pakistan was a submission to the Pakistan court as a matter of Pakistan law. Whether there has been a submission is a matter of Cayman law, not Pakistan law. There's no dispute between the parties about that. It's a matter for this court, so one has to be careful with the submission that's being made against me, which is this was all dealt with by the experts on Pakistan law. That was looking at a different question.
Or was it decided that it hadn't been submission under Pakistan law? Was it?
The experts disagreed.
I know, but what did the judge decide? Or are you saying he didn't decide that?
I don't think he decided it as a matter of Pakistan law. He certainly pointed to some of the expert evidence and said, but I don't think he concluded. That's, as both parties accepted, that wasn't the question. The question is, whether it amounted to a submission as a matter of Cayman law. The point that I'm really making is that in terms of those...
Doesn't he say that in paragraph 194 of the trial judge's judgment? That it's an issue governed by Cayman law, not Pakistan law?
My lady, exactly, yes, thank you. That's exactly the part I was referring to.
Yeah, I mean, certainly it's clear that the ultimate issue is governed by Cayman law, but in paragraph 194, page 215, the judge says it can, however, assist for the purpose of Cayman law analysis in assessing the significance and effect of steps taken by the applicant in the Pakistan proceedings.
Yes.
I mean, if you haven't submitted under the local law, you're very unlikely to have submitted under the Cayman law.
Probably.
It may work the other way around, that a submission by the local law doesn't count you out from challenging the jurisdiction here, but it'd be pretty odd if the foreign court itself didn't think you'd submitted, but we say, oh, it's tough, we're going to treat you as having submitted.
Yes, I mean, in other words, it's a question for the Cayman law, not for Pakistan law. The experts, therefore, their analysis of whether this amounted to a submission as a matter of Pakistan law ought not to be a barrier to this court looking at simply what the facts are, the undisputed facts, which is simply what documents say, and forming a view based on those, which is really the point I wanted to get to.
Right, but I mean, if you're looking at the underlying question, whether there's sort of a true voluntary submission, it's quite clear that the parties were being advised by Pakistani lawyers, and to some extent at least, one would expect the understanding of a party taking a step to be informed by the advice it's received about the local law, so that if they're saying, well, if you do this, you have to appreciate this is going to be a submission to the jurisdiction, that's obviously would be quite a strong platform for saying, and nonetheless they went ahead so that they, with their eyes open, voluntarily accepted the submission. Whereas if their local lawyers are saying, no, in local law this would not be a submission, one might think that that's going to be quite significant in an English court's assessment whether there's been a true voluntary submission.
Well, I can see those points. I think probably there'd be an argument about that for a couple of reasons. One is the cases all say that subjective intention is not relevant. It's an objective assessment. Right. I imagine if someone didn't make that submission, that's the argument you would make back. And also...
sorry, just on that. You can objectively see what advice has been given. You don't necessarily have to say, did they believe it in their subjective...
Yeah, I accept that, of course. The second point is that I don't believe that there was evidence, or at least I don't believe there was evidence on what the parties had been advised. The expert evidence was of course from independent experts, not the lawyers.
One could leave out what they've been advised, but just what the position is.
Yes, and
if you find that it doesn't amount to a submission under the local law, then you might think, well, that's quite a strong reason against it not being regarded as voluntary submission from our point of view.
Well, I
mean, Mr. Raphael in his book, that's quoted on page 297, has a discussion, which I don't know if you disagree with what he says there, but...
sorry, which page?
297 of the... It's in the Court of Appeal judgment.
Yes.
They quote Raphael on anti-suit injunctions, and he talks about sometimes you might have no alternative, but you have to do a step that would amount to a submission under the local law, but that English court might not attach much weight to that.
Yes, I believe that this is in the post-1982 world.
It is, but I'm not sure. I've been left very unclear from your submissions to what extent you say there's actually any difference between the post and the pre-1982 world.
Well, the difference is, my lord, those three points that arise out of the Geoprosco decision, those bright lines, which in my submission are part of the common law. I accept that the 1982 Act was a clarification because there had been difficulties or had been different interpretations in different cases. But actually, on a proper reading of Geoprosco, I accept that that's why it's not an outlier. It's not like actually read properly. This is a case that provides for something outlandish. Actually, it provides something very straightforward and acceptable. And read in that way, there's no reason why it shouldn't form the common law of Cayman unless changed by legislature.
Yes.
My lords, those are my 5 reply points. Thank you very much for that.
Thank you. I don't think there are more questions. Thank you very much.
Thank you.
The board is very grateful to the submissions that we've had both in writing and orally. We need to consider our judgment in this matter. The board will take time to consider what advice they humbly tender to His Majesty. This hearing is now adjourned.